and I welcome the opportunity to contribute to the debate on the Workplace Relations Bill 2014. And as some speakers have outlined, that they welcome the streamlining of the complaints procedures for workers and workplace relations from 5 bodies down to 2. I have to say that I'm not entirely convinced as to whether that's necessary or not. You can see, I suppose, the arguments in favour of it, and that you have a simple procedure for an employee who wants to make a complaint, and that there's a single body and single point of contact for that. But you have to say that, I mean, I doubt very much if by rationalising to 2 bodies that it's actually going to speed up the process or improve the actual length of time that workers have to wait to have their cases heard before a 2-body WRC or before the 5-body Employment Appeals Tribunal, Equality Tribunal, and the other bodies that are there. So I think we'll have to see how your commitment, Minister, in terms of making sure that the new WRC has the resources to be able to move swiftly through the caseload that they have to ensure that the cases are heard within a reasonable time frame. And I think that's something that unfortunately we'll only really see as it starts to do its work and whether it proves to be the case. It's hard to get beyond looking at the reason for this bill, and one of the driving forces behind it is actually a money-saving measure and intended to meet this government's requirements to cut costs at all costs, and to ensure that sums can be saved, even though bodies might actually be working okay and working reasonably well and satisfactory. I have experience of the Employment Appeals Tribunal and rights commissioners from both sides of the argument. It's probably a bit unusual. In some cases I have represented workers there, and I have been before them myself as an employer as well, so I have some experience of going through the procedures there, and I have to say that I find it very fair. I find it something that is good to deal with, and obviously I suppose coming out on the right side of the decisions makes it a bit easier as well. But I think it's something that it does work. The only concern I would have is in relation to the time that it takes to get before one of the tribunals or one of the bodies. The bill provides in section 41 that hearings should be held in other than public session, and I think that shouldn't be included in the Act. I think it should. I think all the adjudication bodies should take place in public. It should be. The current system is a quasi-judicial system, and it takes place in public at the moment, and I think it should continue to take place in public. Now, in my experience in the regional areas, and particularly in Donegal, there's very little. There is no interest in terms of public. While all the proceedings are open to the public, nobody attends and nobody turns up. The media don't turn up. I presume probably because hearings held in Dublin, and there's so much media available in Dublin and so much media around, it's easier to get some media attention if you're a complainant before a tribunal, and it mainly seems to be maybe the possibility of embarrassing an employer or something that is the rationale for getting media attention and media coverage there. And I think in reality there isn't a huge amount of interest in terms of public, but the fact that we having it in public is a reassurance for everybody involved, and I think that's a principle that should be upheld and should be retained in the legislation and the Act in the future. In relation to compliance notices and fixed charge notices, I think, you know, by subsuming NERA into the WRC, that might have some benefits, I would have doubt over the actual enforcement of compliance and the enforcement. The fixed charge notice is obviously there's a mention of a fee, fixed charge notice of €150 or whatever. I don't think that's enough. For employers that are found to be in breach of workplace legislation. I would wonder about compliance notices and whether there'll be any follow-up afterwards. I do know of one case in Donegal where an employer was found to have underpaid staff substantial sums running into thousands of euros by a NERA inspection, and there was no follow-up. The employer simply refused to pay the employees the sums that were adjudicated and decided on, and there was absolutely no follow-up, and it went on for a couple of years that the employer didn't rectify the situation and nothing happened. And I think that's something that anybody that's established has to be ensure that if they do issue compliance notices, that there is follow-up and that the employer is forced to comply. Because the situation, I mean, between an employer and employee is not an equal situation, and the employees do need to have access to bodies such as the Workplace Relations Commission or the Employment Appeals Tribunal or whatever, to be able to have their rights protected. Very few employees nowadays are covered by unions, so employees are basically acting on their own and looking after their own interests and dealing with their employer. And while a lot of employers, and probably most employers, attempt to comply with the legal requirements, quite a few employers don't. I know many hundreds of employees who wouldn't have contracts, wouldn't get pay slips, wouldn't and quite a few who wouldn't be paid minimum wage, and this goes on and continues. So employees need to be able to access these services, and they need to be able to access them easily. Many employees would don't have the benefit of anybody to represent them when they come before and try to exert their rights. And so I think that this system has to be made easy for employees in that way. And I think that would lead me to the potential or the possibility, where it's not intended to do it, but there's a possibility that there could be a system of charging introduced for the WRCs, and I think that would be a very, very worrying step, because it would have the effect of restricting the access of employees to the remedies involved in the Workplace Relations Commission, and I think that's something that shouldn't be implemented. And I'm worried because it's provided for some form of charging. So ultimately, within a year or two, that probably will start to come in, and it'll be because of the workload and the amount of complaints, and that they have to streamline the process, and there has to be some cost recovery, and for those reasons, it'll be brought in. One other item that would worry me slightly in relation to the to the legislation is that where an adjudication officer can decide that a complaint is vexatious or frivolous, and I don't really have a problem with that in principle if that decision is made, but it is open to the complainant to appeal that decision to the Labour Court, and if the Labour Court then decides that the original decision of the adjudication officer was wrong, the case is referred back to the same adjudication officer. I think it should be referred to a different adjudication officer, because I think it would be a natural human condition that if you decide that a case is vexatious or frivolous and want to strike it down, and then it comes back onto your plate again, I think it would naturally prejudice you in looking at the case and in dealing with it in the future. So I think they should be referred to a different adjudication officer from the Labour Court in the case where the Labour Court would overturn the decision of the original deciding officer. So I think a lot remains to be seen as to how this is going to work, and how it'll work in practice. I think that the Minister should give serious consideration to ensuring that the hearings are held in public, and the decision to hold them in private, I think, is a retrograde step. I think you should look at some of the other changes there, and I think also it does require a commitment from government to ensure that the WRC has the resources to be able to work and to carry out its job, and that means getting away from the mindset of saving money. It may require an initial investment to get this up and running and clear a backlog of cases, because I've no doubt that because of the downturn and the recession, there has been a lot of cases have ended up before the tribunals that would maybe in the normal run of things has been over and above. So I think that's something that looking at maybe saving in terms initially in the first couple of years until the backlog is cleared and cases run smoothly, then maybe there might be some efficiencies that can be brought in. But I think there needs to be a commitment there from the start to ensure that the Workplace Relations Commission can actually hit the ground running and do the job and deliver for employees and also employers as well. I think probably one of the things from talking to some employers and stuff, Oh, about the existing system, I think a lot of employers take a strategic decision not to fight cases at the Employment Appeals Tribunal and just to settle before they get to them, just because they don't. They have a perception that the tribunal is more biased towards employees rather than employers. Personally, I don't think that's the case. I think it's just because employers take a decision on a cost basis not to fight a case, that they just pay it off and make it go away instead. So I think that it can benefit employers as well. And I think if employers are proactive and fight cases and also have their systems in place to ensure that cases don't come before the WRC in the first place, it would benefit everybody.